Well, the first time I met Bill Gould was when I was out on campus for Admitted Students Day. And I had sought him out because I was interested in dispute resolution and labor and employment law. And he was gracious with his time to, spend a few minutes with sort of a, newly admitted student. And that time with him helped cement my interest in coming to Stanford, kind of as for law school. And then once there, I had the opportunity to take his labor law class and to connect with him from time to time. I also took a series of courses over at the Gould Center, not after this Gould, but a different Gould, but for dispute resolution. And sort of a combination of his knowing of my interest in those programs, as well as sort of my connections with him through his class, that he sort of, kept me in mind when he had this opportunity emerge. I had Bill as a professor there. And then a few years after law school, he contacted me, not about, sports tickets to the Red Sox coming to Chicago or the Celtics in Chicago, but to work with him closely in designing and implementing a independent monitor program for a company's labor organizing disputes. The company was First Group out of the UK, and they had a series of US operations sort of in the school bus industry, as well as transit, sort of campus and airport kind of transit facilities and Greyhound. And so he invited me to really establish a first of a kind kind of independent monitor program during a company's union organizing campaign. He came back to me shortly thereafter and invited me to be his special assistant alongside of him to really sort of implement this, to coordinate with other investigators that we had on our team, to document sort of the fact finding, to go out in the field and do the investigations, sort of myself. And, I could spend an entire, hour or more kind of describing all the experiences we had there, but as it related to sort of my professional development, this really helped accelerate that. Doing this design, implementing, execution of the independent monitor program. I was still a fairly junior associate when I left the law firm. And when I returned to the law firm a year later, we were still running the program, but it didn't require my full-time attention. I felt like I was operating at a young partner level at that point. And being able to work alongside him and learn from him and his approach to these things, again, really sort of accelerated my own professional development. And I'm grateful for that.
And so when you started with him, you were really building this business from the ground up.
I really have to point to sort of the education at Stanford Law School. So give a plug for the law school there. Just the courses and the opportunity to be sort of a well-rounded lawyer, thinking about litigation angles, transactional angles, dispute resolution. One of the courses at the law school that is offered is complex resolution system design. So that, this fell squarely within that bucket there. And so being able to marry that sort of legal education experience with sort of the labor law and employment law expertise that Bill brought, I think really helped make us a good pair.
During the Obama administration, when I was at HUD dealing with fair housing, and one of the areas of the Fair Housing Act that when I came in, they said, well, here's this called Section 3, and Section 3 is the principle of that the dollars spent by HUD in the community should be used to hire individuals who are either low income or public housing residents. And when I got there, my briefer said, well, this is part of the Fair Housing Act, but it really has nothing to do with fair housing. And I said, actually, it has everything to do with the people who live there. And Bill was very instrumental in advising us on project labor agreements, bringing unions and apprenticeship programs to the table. And I saw that once again, talking about the impact on people. When we went into some of the public housing places in New Orleans, I recall very vividly a woman coming up to me and saying, the Section 3 of hiring individuals who live here, they are building their own community. And she said the best thing is when the fathers and adults come home and they've worked hard and they demonstrate to their children, we are building our community. And that is part and parcel of what it means to have labor law protections, what it means to have equality in fair housing, and also what it means in voting. The ability of individuals to be able to have a voice, have a say, and really direct their own futures. So I appreciated Bill's involvement with our work, bringing together not just housing, but housing and employment, and making sure that the labor issues are part of what we were doing. It hadn't been done before by previous administrations of either party, and we were able to make an impact through that.
So my name is John Holtzman. I graduated from the law school in 1981. I am the managing partner of Rennie Public Law Group, which is a firm that's devoted to representing local governments around the state of California. And my connection to Bill was, he was, of course, my professor when I was at Stanford Law School, my labor professor. I had no interest particularly in labor law, never considered the possibility that I would practice it. And of course, I've practiced it now for 40 odd years, and was head of the labor section of the San Francisco City Attorney's Office, and involved in a lot of the charter changes relating to how the city handles collective bargaining.
And so for a period of time, you have both worked in private practice and with your firm, and also with city government in dealing with problems of the city and county of San Francisco, among others, and that developing solutions to problems that the city and county had.
Yeah, so from the time I ended up going to the city after I was at Morrison and Foerster for a number of years, a clerk before that. But after that, I went to the city, and I was lucky enough to land in a pretty high level job, considering at the time I was 30 years old. So basically landed as head of labor and employment for the city attorney's office, and also at a time when the city was really having to reevaluate how it went about labor relations. The city was extremely antiquated, probably the most antiquated city in the state in terms of how the city handled labor relations. And so it was a critical time in the city, and I was able to participate in completely revamping the system, labor relations systems. That city has, at the time it had about 50 unions, which is far, far more than LA, for example. So to put that in perspective, and very, very complicated system to try to handle. So anyway, that's
So give me a time frame on when you began on that particular project, roughly.
So about 1988. Or 89 or so. The reforms themselves, maybe about 89, I guess, maybe even 90, 89 or 90. And he was brought in. I mean, I was delighted because, of course, I knew him from law school. But he was actually brought in by a woman named Maggie Jacobson, who was a very famous mediator, and who then became head of our employee relations division in the city for a brief period of time, and very, really smart. So the reforms themselves took place really in 91. It was the first big set of reforms, and he was named to a panel, which I guess in retrospect we might have renamed, given how life has changed. It was called the Four Wise Men. So there were four very, very senior employment kind of gurus, all of whom were, at the top of the field. The other one I remember is Walter Kintz, who was a very famous arbitrator. And so he was named to this panel to help us design and for them to recommend, how we should restructure our labor relations going forward.
And so this was really a very complicated project that you were starting on. I mean, just dealing with unions and dealing with 50 unions, and there was a lot of history involved there. And so it was getting everybody to come together on a solution.
Yes, yeah, absolutely. And that was, it's very challenging. San Francisco is obviously one who, excuse me. San Francisco is one, very, it's got very strong labor, as you know, labor unions. It's an unusual city because all of the craft unions, for example, have their own bargaining units, which most cities don't work quite that way. And so you've got all the crafts as well as, of course, police, fire, social workers, whatever. Excuse me. So, yeah, a lot of very disparate interests, very different kinds of unions, very, with really different kind of approaches. It's also a city that has kind of an interesting labor history because it, despite San Francisco being viewed as a fairly progressive city, which it is, it had had a very big strike in the 80s, and the strike had soured the public on the possibility of public sector strikes. And so one of the big challenges was how to come up with a fair system to compensate and negotiate with all these different unions, one that's workable on the one hand, but also took account of this very strong desire by the public not to have strikes, which is something that, in San Francisco, one would have thought could have been a real risk.
And so this was not only a difficult problem you were facing, but it was a unique problem because San Francisco having so many unions is that you couldn't look to some textbook and say, this is how it ought to be organized.
Not at all. There was no model, and to this day, there's no model. And San Francisco has a system that does not have much in common with any other system in the United States.
And so Bill was chosen, and in our previous conversation, it was like Bill was the perfect guy to be in the position to essentially redesign all of the labor relations activities in the city and county and San Francisco and deal with many years of history of how things were done. And so it was his job to be in charge of strategizing and then implementing this huge change.
Yeah, I would say more strategizing than implementing, because the implementing took off in its own world, which is something that actually frustrated Bill a little bit. One thing that happened in this was a lot of his ideas are incorporated in what we ultimately adopted. But one thing in politics is you can never tell when things are going to happen, and the moment for it to happen happened sooner than we really expected that it would. And the thing sort of took off on its own steam at some point. Yeah. And Bill was like, wait, we got to get this right. We got to get this right. And, it's like the idea sort of got out of the gate, and just kept running. But yeah, so he was a critical guy. He was certainly the person who, I mean, we had, the Wisemen were all, really smart, thoughtful folks, but Bill was obviously the biggest thinker in the group about structurally what would work, and he had the greatest access, in a sense, to understanding what models existed out in the world, that could help us.
So, so as things proceeded, was the solution became apparent pretty early, or was it the solution apparent, but it was getting people to line up behind that? And how much was Bill's role in pushing the solution forward?
Well, the core of the solution emerged I think, relatively early on, although I have to say it was a long time ago, I'm not really sure, which was that we adopted a system that was based on interest arbitration. And interest arbitration, is an unusual form of arbitration. Um,
Could you explain interest arbitration?
Yeah, so interest arbitration is a impasse resolution mechanism. So once you've reached an impasse at the bargaining table, in simple terms, really, what happens is an arbitrator can step in and can actually determine in a binding way the terms of the labor contract. So it's different from what we think of as rights or grievance arbitration, because there you're interpreting or applying the terms of a labor contract. In interest arbitration, you're actually creating the terms of that contract. So the structure of interest arbitration, is a very, very powerful tool, but the structure of it is extremely important to make sure that you get decisions that are that are not way out of bounds, because it is a very powerful tool. You're delegating the power of the legislative body to an arbitrator. And it poses so there are issues, for example, about different models of interest arbitration. One big issue is, and San Francisco has this, the adoption of what we call MEDARB model, which is mediation followed by arbitration, or vice versa, so that you're trying to bring the parties closer together on a voluntary basis before you're making a binding decision. So there's a lot of structural issues there. The other complexity was that the San Francisco had so many unions that the question was really, and could we sustain a system whereby potentially multiple unions in any given year could go to arbitration, essentially go to trial, and would the system, would we be able to coordinate a system like that, and what kinds of rules would go into a system like that to allow it to be governable and operable without it being kind of a full-time problem.
And I understand from you that the solution really valued stability over independence, that the unions gave up powers to act and the city, and in return for getting stability and preventing the strikes that have been so harmful.
That's right. Yeah, that was the value in a lot of ways of interest arbitration, was that it prevents strikes. So they're prohibited in interest arbitration, and so yeah, so you're buying a lot of stability. You're also, in theory at least, buying a system that is fact-based. That because the arbitrations are complex. They're based upon issues such as your ability to pay, comparability, looking at things like recruitment, retention, etc. And so this is a system now that's operated in San Francisco since 1991. And although it has not been glitch-free, it has prevented strikes since 1991. And we have not had a major strike in San Francisco, which, if you think about San Francisco and what a dynamic political environment, labor environment it is actually pretty remarkable.
And so, as you were observing Bill and as you were working with him, moving toward this solution, were there any particular moments that stand out to you, and that he did something that other people might not have been able to do, or had a viewpoint and a perspective or a strategy that other people wouldn't have been able to figure out?
Well, I think I think that Bill came at it, I mean, it's not going to come as a surprise as anybody. Bill is pretty pro-labor. And and so I think the biggest thing Bill did was really more that he I think he had a ton of credibility with the unions. So to me, I think the biggest thing, he was the big respected guy for labor. And there were unions that were very hesitant. There were two unions, SEIU and Local 21, that wanted interest arbitration. I think it's fair to say all of the other unions were either neutral or negative on the idea. Getting people to the point, and by the way, it took longer. There was a second charter amendment in 1994. So the 1991 charter amendment, this was not Bill's idea. In fact, he didn't like this idea at all. The 1991 charter amendment was opt-in to interest arbitration. In 1994, everybody was actually put into interest arbitration, whether they wanted to be in it or not. So it took a little while, even after we'd established it. By the way, the city has used him in arbitration, or used him, as well in that setting. He's clearly, the guy to go to when you want somebody with deep knowledge, and a deep understanding of how these things will work. I mean, among us labor lawyers, there's probably a dirty little secret that, we have little compartments for different types of arbitrators. And, there are some cases that are better for an arbitrator who's not thinking too deeply. And yeah. You wouldn't want Bill on that case. The system has worked. I mean, recently it has had some challenges with PERB, interestingly, with the Public Employee Relations Board, and there've been some things have shifted in some ways. So there are aspects of the system that are beginning to fall apart a little bit. But, if you think about a system that has lasted 91 to now, so more than 30 years, through a lot of change in law, because California labor law has changed a lot over that time. It's done incredibly well. We haven't had strikes in San Francisco. Labor costs in San Francisco are, they're on the high end of cities, but that's not terribly shocking, because the cost of living in San Francisco and wealth, et cetera, is also on the high end of cities. It has not been disastrous, which is what we all feared, honestly, that that it would just be a huge cost driver. And it has kept labor peace. It's also a system, and I don't remember whether Bill was involved in this part of it or not, to tell you the truth. It has very, very, very tight timelines. And so there are really only 3 months a year in any year when labor contracts are open, where this process goes on. So it's unique in a different respect, which is that it compresses the labor negotiation process into a relatively short period of time, which I personally think is a great thing. And I say that despite the fact that I make my money from labor negotiations, because labor negotiations aren't like a fine wine. They don't get better over time necessarily. And getting them done in an expeditious way, especially when you've got 50 unions, now they have somewhat fewer because they've collapsed some of the bargaining tables, but getting them done in an expeditious way so that you're not constantly dealing with open labor contracts is great. And so in a lot of ways, I mean, I think maybe it's telling that there is not, and has not been for 30 odd years in San Francisco, a press to change the system in any broad way. I don't think there's any accomplishment I can point to in, well, maybe one other in my career, that is comparable. And this is, looking again, I'm just talking about myself here. This is really about Bill, but the value to me, having been able to be involved in designing this, complex, one-of-a-kind system for a very complex city that has, that has worked at a level that most cities have not been able to achieve. And I'm talking big cities like New York or anything like that, where we are able to get labor contracts in place. We have pretty good labor peace, actually pretty positive labor relations overall. I think, I look back on it as probably one of the 2 or 3 biggest accomplishments of my career, and obviously never would have happened without Bill.
Oh, I think he's, very good at trying to find sometimes the different angle that people maybe, didn't identify that could unlock a solution to a problem. I mean, right now, he is giving the labor unions a tough time because this is an enormous opportunity for them, he sees, because public support for labor unions is the highest it's been since probably the mid-1960s. And, he sees it as a great opportunity, but he doesn't want complacency. But he has shown some additional tools that can be used in disputes. Like, for instance, Bill has pointed out how antitrust law sometimes can be used. Apple kind of conceded, neutrality in a labor struggle because they were worried that the unions were going to take up Apple for antitrust violations, which they probably are very vulnerable on. Many of these big platform capitalist companies, and Apple's gotten very involved in that space. They're very vulnerable. So when Bill looks at a problem, sometimes he does find another angle that maybe none of the other people have been thinking about. But at the same time, he really does challenge people in the labor movement. He really has embraced this new study by a fellow named Chris Bonner, who's shown that the labor unions between 2000 and 2020 have had a big increase in resources, but many of them, a few exceptions, but many of them are not putting those resources into organizing activities. And Bill is giving them a tough time about it, including we had him in our classroom at Harvard for the Harvard Trade Union program. And he, really was pushing the labor leaders to see, that this is an opportunity, especially, I appreciate how much Bill's in touch with the energy of young people. We have all these young people, many of whom had no familiarity with unions, and they're organizing at Starbucks. I saw the Trader Joe workers organizing. Even that Amazon warehouse in Staten Island that got organized. That was quite a surprising outcome to many people. But, Bill's paying attention to these things and opportunities, and he's telling our labor movement that you've got to find a way. And there are more tools and things out there that you can discover if you, really put your mind to it. And what I like about Bill, I say this to my students a lot of times, some of the knowledge we're giving you in the labor movement is sometimes we like to talk about people need to have militancy and passion, but we don't want mindless militancy. We need the good ideas that are going to help you ultimately triumph. And it's not enough just to have passion and being angry and out in the streets. You really got to have a good strategy. And Bill does give people some really good ideas on how they can intervene and fix difficult things and challenges that they're dealing with.